this bill, I first want to seek leave to have permission to have a cognate debate to cover items 2, 3, and 4. As Mr. President, they're all related. So I'm seeking leave to allow for a cognate debate.
The question is that we consider items 2, 3, and 4 in a cognate debate. Of course, the matters will be voted on individually as per usual procedure. Honourable senators in favour, please say aye. Aye. Those against, please say no. Methinks the ayes have it. Proceed, Senator Walker.
Thank you, Mr. President. Mr. President, this bill is part of, I almost say, an arsenal of legislation that this government has brought as it relates to corruption and to illegal activities in this country. I believe it was in 2019 we had the anti-corruption bill. We subsequently had a bit of legislation that provided for the establishment of a unit to deal with anti-corruption and fraud unit. And earlier today we've had the procurement bill, sorry. Now, this afternoon, we're looking at two bills, all related to matters of illegality and illicit efforts, and indeed corruption to some extent. The whistleblower legislation is one that we've been speaking about for some time, and it has to do with the whole process of the reputation that Barbados has suffered over the last few years, primarily, as it relates to issues of the perception within the society that there is extensive corruption in our society, and we need to deal with this. Regrettably, Mr. President, efforts normally to conduct investigations have usually been stymied, especially in a small society like Barbados, where persons who have information, vital information, usually have a reluctance to come forward and give evidence that might be helpful. Obviously, largely because in many instances, the individuals with the evidence have sometimes been party to or facilitated the corrupt or illicit activity, and they fear that they would suffer severe penalties if they come forward now, more or less, and speak of these. So there's obviously that issue of fear. But before I go further, perhaps you should, and based on the bill before us, it states in the definition of a whistleblower, person who is personally aware of improper conduct and who intends or attempts to make or makes or has made a disclosure. And it says so clearly that this is not only to deal with corruption, but it speaks to improper conduct. So it could be a number of things. This does not only apply to financial aspects and fraud, but all aspects of wrongdoing. As I was saying, sometimes the person fears that their fears of coming forward and facing certain consequences. And so this bill is about to allow persons to come forward and give evidence without having a number of these fears removed. It seeks to give the persons protection, and it also seeks to give them the feeling that if they come and give evidence, that they will be protected within the law. Mr. President, in developing this bill, I'm told that the persons involved in the Attorney General's Chamber looked at a number of similar legislation in countries, New Zealand, Canada, Australia. But I've been informed by them that they also look at the Jamaican legislation. They recognize how extensive that in New Zealand was and indeed in Canada. But they thought that the Jamaican legislation was based mere similarities that we encounter, and obviously smaller circumstances, less resources, was one that they thought that they could facilitate and fulfill our requirements. I want to say at the outset, I've also been told that there was extensive consultation with the Bar Association, and a number of memoranda and suggestions were prepared and provided by that association, and that there was extensive consultation with Integrity Barbados throughout the whole process. The objectives basically to encourage and facilitate the making of public interest disclosure by and against public officials, and I said not only as related to corrupt matters. Ensure that they facilitate the gathering of evidence for the purpose of investigating illicit practices in Barbados, and for the purpose of prosecuting individuals for such corrupt acts. It will then seeks to ensure that individuals who make public interest disclosures are not made subject to adverse consequences as a result of making as such disclosures. And this is what I referred to earlier. This bill includes certain various features. And it says that individuals will not be subject to any civil, criminal, or administrative liability for making public disclosures. And an individual will be able to benefit from immunity from civil, criminal liability to which they would ordinarily be subject, where that individual makes a public interest disclosure. Of course, the protection would extend to defamation actions, and an individual making a public interest disclosure would be protected from any reprisals or threat of reprisals. The identity of the person making the public interest disclosures would be protected, and the person making the disclosure would not be protected from liability in the event that that individual gives false or misleading information. And disclosures can be facilitated by way of verbal evidence or documentary or other evidence. And essentially, Mr. President, that is an outline of the bill. As it is, there are, and I'm not going to bore this honorable chamber by going through all of the parts and sections. Suffice it to say, Mr. President, that there is an extensive explanatory memorandum attached to the bill, and that speaks clause by clause the various aspects that are covered in the various parts. As it relates to the other bill that I'm just seeking to link, the remediation deferred prosecution bill, briefly, this speaks to the recognition. And first I should say, this bill was here in August, before this honorable chamber in August 2020, originally. And with the prorogation of Parliament, it obviously ceased to exist then. So honorable members would have had an opportunity back then, they were dated, to have had sight of this bill and be very familiar with it. A simple one. It's giving law enforcement alternative methods of punishment for those companies or individuals who have been involved in wrongdoing. This could be financial or otherwise. And it simply allows the state to have the option, of course with the clearance of the court, not to prosecute an individual, but to allow them to make good the wrongdoing they have done in terms of the society. For example, a simple matter, one that comes up quite often in Barbados, the matter of companies doing illegal dumping. They could be prosecuted. Someone could be sent, manager or whatever, could be sent to jail for the matter. But the contaminants, the material that has been dumped, be it in a quarry, be it in a water course, is still there, and then physically has to be removed. There could be a fine, but that the issue that was the illegal activity still has to be addressed. And in a situation like that, I'm just giving an example, that rather than confining that one and sentencing that one, they could be asked to bring remedy to the matter that they caused, and in addition to doing that, be asked perhaps to beautify the surrounding areas. So things like this to allow you, I believe the attorneys among us speak of restorative justice as it relates to criminal activity. So this is bringing it into sort of civil facility. Again, they looked at the need for transparency, and they looked at the UK and the Canadian legislation. And again, there was consultation, and the decision was made, as I said, that this is something that was necessary and needed for some time. I believe the Bar Association was also calling for this piece of legislation. Similarly to the whistleblower legislation, again, it has an extensive explanatory memorandum. For those who are wondering about the link in terms of me seeking permission to have a cognate debate, clearly the example that I gave earlier, perhaps if a business had hired a truck driver to go and dump something illegally, and that truck driver recognizing that the activity that he was being asked to do by this company is an illegal activity, he could become a whistleblower and be protected. Whereas this bill could be applied to the owner of that business. So there is that link. Finally, Mr. President, it necessitates item number 4, an amendment to the Constitution. Currently, the Constitution stipulates the powers of the Director of Public Prosecutions. It does not allow for this sort of activity. And essentially, the amendment is seeking to widen the powers of the DPP, not to constrict them, not to reduce them, but to give him certain powers which now don't exist. And Mr. President, in this setting, I believe that I'm being concise and simple, and I beg to move that this bill do not be read a second time. Thank you.
Thank you very much, Senator Walcott. Senator Boyce.
Thank you for acknowledging me, Mr. President. I was caught a bit off guard, hence the mic being off and the mask not being fully equipped. Sir, I rise to join this debate, cognizant that this legislation forms part of, I think the term used by the leader of government business, the much vaunted arsenal by the government to bring corruption to its knees and seek to lay the framework for adjusting and creating a more just society. I think, sir, that no one can have a philosophical, moral, ethical objection to the legislation. And I find myself encouraged to speak the fact that, one, it relates to elements of the Constitution, as well as to a change. Some would even say maybe the basis of a new dawn for how prosecutions are done in this country. I must say, sir, that I am not a criminal lawyer, nor am I a criminal lawyer. My practice is limited to a civil sphere, sir. And what I did, though, was to seek to consult with those of my peers who find themselves in the trenches, sir, with regard to the proposed bill, to get their comments, sir, and to also speak to some friends internationally who were former district attorneys, assistant district attorneys in the state, sir. So the contribution which I propose to give is one which is not really meandering, but seeks to highlight certain areas and see how these areas can hopefully play a part as we choose the utilization which will lead our country forward in a better place. As set out by the leader of government business, this is a form of restorative justice. Now, restorative justice, to get into the definition, believes that you're not really punishing, which is really an aspect of it, but because of certain constraints, you're seeking to rehabilitate and to allow for a return to society of the individual. Punitive justice, which is the norm, and which I dare say hurls a strong position in a post-colonial slave society, sir, now cloaked in the mantle of a republic, believes that these persons should be lost way. So you're going to have an attrition, sir, forgive the colloquial, you're going to have an attrition, sir, in terms of the philosophy of seeking to apply restorative justice to a society which is accustomed to punitive, sir. But we recognize that this is like everything else. I saw, an aside, sir, I saw Sir Lewis Hamilton being knighted, and it is amazing how a knight looks in 2021 and how a knight used to look. I won't get into the discussion about our latest national hero because that caused some concern when voiced elsewhere. But the point is this, sir. As times change, society changes with it. And then the perception, which then informs the reality, also goes about that process. So in keeping up with these changes, sir, we look at this element of restorative justice. For want of a better term, sir, plea agreements, as they're known, basically say, heaven forbid, Mr. President, you find yourself charged, which let's not use the example. Heaven, we see an individual is charged and they're accused of a crime. Utilizing the process set out in this legislation, the power is therefore granted for that individual through his lawyers or through the court to say, I will not be contesting these charges, and there be a deal worked out by which the charges will be reduced or some form of recompense is provided, either physically or financially, sir. So plea agreements are very common throughout the world. They're utilized in the UK, made famous by the US. They're big in Canada and utilized in Jamaica and Trinidad. Indeed, my people tell me, and so does Google, that about 90% of all criminal cases are settled by pleas rather than by going to a jury. So of course, this has the attendant effect of resulting in a reduction in the backlog, which we do recognize is quite significant in the criminal and, dare I say, the civil courts. I'm sure Senator Sands, who is a criminal lawyer, but not a criminal lawyer, will be able to speak to the situation. Sir, the fact is that this allows and leads to quicker justice. But what you do lose, there's always a trade-off, is that now juries are not involved in the process. So like everything else, is a give and take. And when we go back to the first point about the concept of justice being punitive, we should anticipate a certain amount of pushback within the society who believe that this bill could be used as a mechanism to allow persons to get way. So we have to find a way to get the messaging correct where the pros are set out. Sir, I appreciate certain safeguards. Firstly, the fact that the court is involved in considering the agreement and making sure it's the interest of justice, I think should be lauded and provides a nice protective stopgap. Philosophically, I will disagree with the leader of government business in which he says that it widens the power of the DPP, although technically the DPP didn't have this power before. But from my perspective, sir, the DPP currently has the power in the Constitution to stop any prosecution. So if you have such a wide power to step into any prosecution, take it over, and tell that prosecution to stop, that's the greatest possible power you have in relation to taking over a criminal process. What is being sought here, to me, is almost a lesser aspect of that power, but falls within the frame where you say, in coming to a just decision, you, DPP, are given the power to negotiate and come to an agreement with the other side, and we rely on your discretion and that of the courts. So, sir, philosophically, I have no opposition to this, and I believe that the safeguard of the court is something which would always be mindful and should be utilized. However, there are always notes of caution. In Trinidad, the DPP in 2020 said, our ambition must never outpace the support systems. They have the plea bargaining in place, but it was a question of the DPP's office being given the necessary resources to utilize. We're talking about financial, we're talking about technical, and we're talking about human. So the DPP's office needs to be given the resources to actively implement this new power. Because if we're going to have the benefit, we're going to need to give them the power to be able and the resources to utilize the plea bargain framework. And of course, sir, we have to make sure that the public is educated, because essentially it requires two to tango. So if you don't have persons understanding as to the concept of plea bargaining and what it means, they're not going to be receptive to the offer. They might also believe that they're being tricked, and they also believe that they could be manipulated. There's a strong element of public incentive, especially when you're looking to move away from a punitive aspect. We should always be cognizant, sir, of the victims in these circumstances. Because we sit here and we say, well, this will allow for faster justice, and this will allow for better implementation, and this will allow for reduced sentences. But the persons who feel the pain of the victims, and the victims may say, well, what about us? What about us in this circumstance where you're doing this for persons who are accused of crimes to allow them to get a lesser sentence? So we have to see how we can accommodate that perspective and acknowledge how maybe there is a resolution to the trauma by having the matter dealt with swiftly. Maybe it is a question of justice actually being done, and that may give some small comfort. Again, that's not for us to decide here, but it is something that we should be mindful of in terms of the messaging. We must never forget the victims of the actual crime, sir. Sir, with regard to the whistleblower legislation, it is to be lauded, and again, provides another weapon for the battle against corruption. The practical concern remains resources, financial and intellectual, to support this endeavor. Long story short, sir, how do we make persons be comforted enough to say, I am willing to be first whistleblower? That message has to come from on top. In terms of our society where there's so many open and well-known secrets, and where I can hear persons tell when the actual election date is and who doing what and where with whom. If we are to take this seriously, we need to ensure that we have public knowledge and the resources being given to protect these persons who come forward. But most importantly, sir, the confidentiality of the whistleblower needs to be protected, and I see it is given in the legislation. But we can legislate from here to Good Friday, sir. The question remains in the implementation. In the implementation and the need to secure those persons so that they come forward and they're willing to come forward. It is going to be, I say, sir, a bit of a battle, but I believe it could be done. I also like, sir, the utilization of the injunctive powers which are set out in Section 21. And what that means, for lack of a fancy word, is that if an individual finds himself being pressured in a situation within an organization, and the organization takes steps to say, well, you're going to be fired or terminated because of what you're saying, that individual can seek injunctive relief from the court, which says, please, court, protect me in the meantime. This should hopefully dissuade those who will seek to realize the same justice system that we spoke about in terms of being backlogged and utilizing it to say that, listen, well, I will fire you and you will wear that out 5 years later when the ERT finally gets around to it, if that's the case. So, in closing, sir, I support this legislation, and I think that we need to be mindful that legislation aside, we must all take a look at what examples we set as individuals. We need to give persons the comfort that the government will protect them if they step forward. We need to ensure, and I see the fines are there, but we need to ensure the professionalism of the resources and the training to protect those persons who come forward, to bar them from any harm for individuals who might seek their revenge. But most importantly, we have to get the message out there that we are committed to making this work, and we will protect you when you come forward. Thank you, Mr. President.
Thank you very much, Senator Boyce. Senator Hunt.
Good afternoon, Mr. President. Thank you for permitting me to make a short contribution to this debate. I have focused my attention primarily on the whistleblower protection bill. in going through it, a bill which I'm happy to see reach this place, a bill that I am happy to be a part of the ushering in, because it is much needed, as has been stated by my colleague senator who spoke before me. My ever studious schoolmate, Senator Boyce. There are a number of matters of concern that I wish to share about the bill. I hope that my use of the term matters of concern does not connote that I have a problem with what we're doing today. They are simply, as said, matters of concern. We are speaking about protecting employees who whistleblow against detrimental action. And the bill provides examples of what would be considered as detrimental actions. The first thing that came to mind here is the need to be aware and acknowledge management rights. Often when we consider, particularly those of us who have spent a lot of our professional time focusing on the protection of workers and workers' rights, we have to acknowledge that there is a concept, management rights. And among those lists of rights that management or the employer would have, you would find the right to decide when a job should exist no longer, when employment will be terminated, essentially. Employers have the right to order their business in a way that best suits the needs of that business. An example of detrimental action contemplated by the legislation is transferred against his will. That an employee is transferred against his will. The mere fact that an employee is transferred does not mean that something detrimental has happened to them. The fact that that transfer has been effected against the employee's will does not in itself speak to a wrongdoing. In other examples that speak to management rights under Clause 2, I see that we have, I think, appropriately inserted the word unfairly, such that we are indicating that unfairly, if an employee is unfairly dismissed, suspended, or demoted, that's an example of a detrimental action. I think the intention would be better realized had we also included unfairly in that example which speaks to the transfer. So that I should have read unfairly transferred or unfairly transferred against his will. Right? But I think that notwithstanding, the essence of what we're trying to address is still covered. Another significant feature of this bill for me is its reference at various points to the Employment Rights Act. It does so in its reference to the meaning of employee and its meaning of employer. Those definitions are to be found, we're directed, within the Employment Rights Act. And interestingly, rights for redress are created by this bill that reach over into the Employment Rights Act, so that we are likely to see employees who have exercised their duty under the Whistleblower Protection of Whistleblowers Act, triggering rights under the Employment Rights Act, which means that that Employment Rights Tribunal, which is severely under-resourced, is going to have even more work coming its way. And at this stage, I wish to reiterate a call for the Employment Rights Tribunal to be given more resources in order to continue to churn out its jurisprudence, which is very much needed. The tribunal is in need not just of additional staff, it needs a secretariat, it needs something as basic as a place to meet. There are persons who have been waiting to have their cases heard, going back more than 6 years. There are persons who may not understand that in an effort to address the backlog of cases before the tribunal for determination, that an approach appears to be taken where more recent cases are being dealt with and old cases are also being dealt with, right? So that more recent terminations do not just simply add to a backlog, a long backlog. So some persons may be saying, but when you read the reports, here it is that a person was terminated after they were terminated or after somebody they know was terminated, and they have been able to have a hearing and have their matter settled. Why are they still waiting? People may not understand the approach being taken to managing the caseload, and they may unfairly get the wrong impression about the tribunal. I think we really need to be fair to the tribunal. We need to be fair to our aspirations, our hopes for the industrial relations system as far as that goes, and to direct some resources in that direction. There is already a duty existing under the Public Service Act where employees were required to report any illegal, improper, or unethical activity that they were aware of. What this legislation does is it corrects a deficiency that came with that obligation under the Public Service Act. Because the Public Service Act did not provide for those employees, those civic-minded employees, it did not provide the protection that this whistleblowing protection legislation will give. And for that, the effort to do so should be recognized and applauded. There was just one other feature of the bill which engaged my curiosity. I didn't have sufficient time to tap the intellect of my learned friend Senator Boyce or Senator Sands or even the Deputy President. But this act is said to bind the crown. And as an aside here, clearly we will need to make necessary amendments where the act refers to the crown, and then other parts where the act refers to the police force, which I understand will be referred to as the police service. But the act is said to bind the crown. The Employment Rights Act, however, does not bind the state. Right? So when an employee acting under this act, which binds the Crown, finds themselves in a situation where they have to pursue a right under the other act, which does not bind the state. How is that apparent conflict? Maybe it's just an academic conflict, but how is that resolved? As a student of the law, such things will attract my attention, and it is one area that I would wish us to give some consideration to. All that having been said, sir, the initiative being taken today is one that I support, and I'm obliged to you for this opportunity to express that support.
Thank you very much, Senator Hunt. Senator Dr. Rogers.
Thank you, sir. I'm not sure if this is the time to speak about it, but in the constitutional amendment, I think there's a typo there that needs to be fixed. After section D, it should just be a full stop. The semicolon and the and should be removed, I believe. Given that section D is now the end of that, paragraph D is now the end of that section.
Thank you, Senator Dr. Rogers. We're showing in committee the full examination of that. In the meantime, the clerk is checking. Any other speakers on this matter? If not, Senator Dr. Walcott. Oh. His Honor Senator Greenwich.
Thank you very much, Mr. President. Mr. President, I would want to make a short contribution on the whistleblower legislation as well. Senator Rogers, I think that pretty red light is still on. Yes. And about 2 months ago, I think it was in October, to be precise, there was a prevention of corruption bill that came before the Senate. And I remember on that occasion, Mr. President, I spoke about some persons who were in supervisory positions in public service, who, when asked to write reports on employees who were working in their department and who was not really pulling their weight, that those supervisors said, I don't want anybody to burn down my house. I remember that clearly, because the supervisors and so on, they feared that they would get what Barbadians call the dirty end of the stick. I had heard, sir, about some of the employees who went to the bookies and so on at lunchtime and never returned. And so when the supervisor was asked to write a report, they said, no, I'm frightened, I'm not doing it. I remember, too, that I had also mentioned the case where there were 13 witnesses in another jurisdiction, and when the actual case came to be heard, there was only one who was alive. At that time, all of us in here highlighted the need for whistleblower legislation. But what I also can remember, sir, is that during that debate in the other place, that there was one particular person who had expressed disappointment that a whistleblower clause was not actually inserted in the prevention of corruption legislation. they wanted a particular section in that legislation to deal with the whistleblowing aspect. And others had gone even further, and they had said that the Attorney General had omitted to include that particular section, and some criticized him for it. But the Attorney General had said that there was no omission whatsoever. In fact, what he said is that there would be an expansive piece of legislation on whistleblowing which would come later. He said it was in the works and that it would be coming shortly. He said at that stage, sir, that the legislation would be like the whistleblower legislation that we're dealing with, would be like a broad umbrella. And under that particular umbrella, you would find prevention of corruption, and you would find other forms of improper conduct which would be included. In other words, there was this overarching legislation on whistleblowing, and other things would fall under it. And today, I am happy to see, sir, that the whistleblower legislation is here. It strikes me, sir, as a promise which was made and a promise which was kept. And I know that some of us would like to criticize the Attorney General from time to time, and there are times when he should be commended, and I would want to commend him for bringing this particular piece of legislation to us. I think he got back to the country. I think so that he got back to the country in good time with the piece of legislation. And clearly, as he said at the time, sir, it was in the works and it is now here. Now, if I look at the objects and the reasons for this particular piece of legislation, I think it is fairly clear. It says under the objects and reasons that this bill would deter and combat corruption, yes, corruption, and other improper conduct by encouraging and facilitating disclosures of such conduct, protecting the persons who made such disclosures, and regulating the receipt, the investigation, and other treatment of such disclosures. So we have there precisely what the bill is meant to do. My concern is a bit different. And yes, I do have a concern. And what I can say is that I know of cultures, other countries, but particularly, sir, other cultures which say and which tell us and which tell the world that where corruption is concerned, every silent onlooker is either a coward or a traitor. In those cultures, Mr. President, you're told that you must speak out. In those cultures, Mr. President, you are told that the biggest encouragement for bad men to keep doing what they are doing is for good men to look on and say nothing. And if you want me to repeat that, I can do it, sir. The biggest encouragement for bad men to keep doing what they are doing is for good men to look on and say nothing. In those cultures, sir, you're told that to know what is right and not do it is want of courage. You're told in those cultures, sir, that you should not allow fear for yourself to overpower your sense of duty to your country. And as I think it was Senator Boyce who hinted, that some of those tenets, some of those cultures and so on, may not necessarily be the ones to which we are accustomed. This does not mean, Mr. President, that I'm saying that this will be useful or useless legislation. This will be useless legislation. I'm not saying that at all. I'm saying so that I do suspect that will be on occasions when we are going to have a battle between this legislation and our culture. And sometimes our legislation may even lose the battle against our culture. Because our culture, you see, Mr. President, is a stay-in-your-lane culture. Whether we like it or not, our culture is a stay-in-your-lane culture. Our culture, Mr. President, is a see and don't see culture. Sir, our culture is a hear and don't hear culture. Our culture, Mr. President, is turn a blind eye whenever you can. And that is where we are going to have a fight. You see, Mr. President, the combination of that preferred silence and indifference will be the biggest obstacle to this legislation. We belong, Mr. President, to a don't rock the boat culture, whether we like it or not. That is a fact. And so, Mr. President, I would never try to downplay such an important piece of legislation. In fact, sir, I would join and encourage all Barbadians to speak out, particularly now that they can be guaranteed protection under this legislation. And if we would just look at the definition section of what is meant by improper conduct, you see, sir, it says criminal offense. Improper conduct includes any criminal offense, and then it goes on to list a number of others. This includes, sir, it says conduct that is likely to threaten the health or safety of a person. That is D. And E says conduct that is likely to threaten or damage the environment. Conduct that shows gross mismanagement, negligence, impropriety, or misconduct in carrying out any activity that involves the use of public funds. So they've listed the number of things which I suggest and I encourage you to blow your whistle on. Where you see illegal dumping, Mr. President, I say speak out, blow your whistle. Where you see child abuse, Mr. President, I say speak out, blow your whistle. Where you see spousal abuse even, speak out and blow your whistle. You see, sir, I, like all right-thinking persons, agree that it is our civic duty. It's the civic duty, sir, of each and every Barbadian to do whatever is necessary to make this country a better place. And you have a civic duty to report what they call improper conduct, unlawful and illegal practices that are going on right before your eyes. Report them to the authorities, Mr. President. When I was reading the legislation, sir, one thing that occurred to me as I read it is that this legislation assumes that the whistleblower will exercise a washpan of common sense. As I read it, that is what came home to me. Nobody is going to know who blows or who blew that whistle. But the whistleblower has to be discreet too. The whistleblower has to be discreet. And the whistleblower, I'm saying, sir, should not let the left hand know what that right hand is doing or what that right hand has done. If, sir, the legislation is protecting you, the whistleblower, then you also have a duty to protect yourself. And you should not even tell your best friend, for instance, that you have blown the whistle on X or on Y. Because suppose your friend says to you, sir, I hear that somebody called the police on the fellas around the corner. You know, sir, that is something that you shouldn't even say or even whisper to your friend, I'm the person who did it. Because in a very unguarded moment, for instance, that friend may tell someone without even thinking, yes, so-and-so did it. And so I emphasize the point, once again, that the whistleblower must be discreet. The whistleblower has to be sensible. So, sir, the fundamental remit of this legislation is to give persons the assurance that if and when they blow the whistle, if and when they blow the whistle, that they will not be disadvantaged in any way. I think I made the point of it that the national interest never seems to take pride of place over self, where some Barbadians are concerned. That people love to keep things close to their chests rather than put them in the public domain. That the usual response from Barbadians is quite often, who, me? Not me. And I was reading what hit me hard just a few days ago, I was reading the newspaper, and there was a son who he had lost his father in a motor vehicle accident. And I also heard him on the radio as well. And he was making a plea for those who had seen the incident to come forward. And you could almost hear it in his voice that he was saying so, almost knowing that the people would not be lining up to come forward to give this information. And this is the culture that I'm talking about. And so, Mr. President, what I'm saying at the end of the day is that legislation is one thing. It's one thing, I agree with that. And in another early debate today, I think it was Senator Rogers, who I heard make the point that the problem with us is not legislation. I think he went on to say that, yes, it was Senator Rogers, he went on to say that we have a lot of good laws around here. The point is not the legislation itself. Achieving the intended result is another thing. The legislation is one thing, but achieving the intended result is the key and the crucial thing. And we cannot ignore the culture that we are up against. In fact, Mr. President, you and I know only too well of a former cabinet minister that sat beside the two of us, who once told the Prime Minister, with a certain tone in his voice, Prime Minister, you can't legislate to kill a culture. That is it. The legislation we have here is good legislation, yes. But if I had to quote from a gentleman who is now our commissioner in Ottawa, Canada, I would have to go with him and I would have to say, Mr. President, you can't legislate to kill a culture. I'm obliged to you, sir.
Thank you very much, His Honor, Senator Greenidge. I know that you have come from near a very outstanding most honorable Calypsonian. But I thought that you were trespassing on his territory and you were creating a song called Blow Your Whistle. But I think you should consult with Senator Dr. Rogers. He is an expert in Calypso, and he will guide you accordingly. But I was liking the song. I think you'll be ready for 2022. Blow your whistle. Thank you, Senator Greenwich. Senator Walcott.
Thank you, Mr. President. I want to thank all honorable members who've made contributions in this cognate debate, and I have made note of some of their comments and indeed their suggestions. I noted the comments made by Senator Boyce in relation to the additional resources that will be needed in the DPP's office and the important role in terms of public education that will be necessary, and the point that he made, the need for financial and intellectual resources. Senator Hunt, again, his points was noted in terms of the links with the Employment Rights Bill and the needs of the Employment Rights Tribunal. And I've also noted those as it relates to the Secretariat, place to meet, and the matter of the backlog. First of all, he made a mention, Senator Hunt, this is as it related to the use of the word crown and references to police force. And I take the point, recognizing, of course, that this bill was prepared some time ago. But we did an amendment to the Constitution just prior to going to Republic, and I am informed that the Interpretation Act shall apply with the necessary adaptations for the purpose of interpreting this Constitution, and otherwise in relation thereto as it applies for the purpose of interpreting and in relation to an Act of Parliament passed after the commencement of the aforesaid Act. In that relation, when we did the amendment, we said the Constitution is amended by deleting the word crown wherever it appears and substituting the word state. Similarly, the words police force wherever they appear and substituting the words police service. And I'm informed that this will be done by the Law Revision Commission when it leaves here. Similarly, Senator Rogers, who indicated he had absolutely no intention of speaking, made the point about the insertion of an and. And again, Mr. President, I thank him sincerely for pointing out that typo, which will no doubt be addressed. Mr. President, I think in this season and the time of the year, it seems that we have managed to reach some concurrence as it relates to this matter, these matters here. And I'm delighted to be in a position to say so. And before the mood changes, I want to beg that this bill be now read a second time.
The question is that this bill be read a second time. Honorable senators in favor, please say aye. Those against, please say no. Methinks the ayes have it.
Mr. President, I beg to move that Your Honor do not leave the chair and the Senate resolve itself into committee for further consideration of this bill. Thank you.
The question is that it do not leave the chair and the Honorable Senate resolve itself in the committee for further consideration of this bill. Honorable senators in favor, please say aye. Those against, please say no. Methinks the ayes have it.
The Senate is now in committee.
Mr. Chairman, we are again seeking the concurrence in calling this bill in parts and clauses.
Permission granted to be done in parts and clauses.
Part 1, clauses 1 to 3.
Mr. Chairman, I beg to move that Part 1, clauses 1 to 3 stand part.
The question is that Part 1, Clauses 1 to 3 stand part. Honorable Senators in favor, please say aye. Those against, please say nay. Methinks the ayes have it.
Part 2, Clauses 4 to 12.
Mr. Chairman, I beg to move that Part 2, Clauses 4 to 12 stand part.
The question is that Part 2, Clauses 4 to 12 stand part. Honorable Senators in favor, please say aye. Those against, please say nay. Methinks the ayes have it.
Part 3, Clauses 13 to 15.
Chairman, I beg to move that Part 3, Clauses 13 to 15 stand part.
The question is that Part 3, Clauses 13 to 15 stand part. Honorable Senators in favor, please say aye. Those against, please say nay. Methinks the ayes have it.
Part 4, Clauses 16 to 23.
Mr. Chairman, I beg to move that Part 4, Clauses 16 to 23 stand part.
The question is that Part 4, Clauses 16 to 24, to 23, stand part. Honorable Senators in favor, please say aye. Those against, please say nay. Methinks the ayes have it.
Part 5, Clauses 24 to 31.
Chairman, I beg to move that Part 5, Clauses 24 to 31 stand part.
The question is that Part 5, Clauses 24 to 31 stand part. Honorable Senators in favor, please say aye. Those against, please say nay. Methinks the ayes have it.
First schedule.
Chairman, I beg to move that the first schedule be the first schedule to the bill.
The question is that the first schedule be the first schedule to the bill. Honorable Senators in favor, please say aye. Those against, please say nay. Methinks the ayes have it.
Second schedule.
Mr. Chairman, I beg to move that the second schedule be the second schedule to the bill.
The question is that the second schedule be the second schedule to the bill. Honorable Senators in favor, please say aye. Those against, please say nay. Methinks the ayes have it.
Mr. Chairman, I beg to move that you do now report to His Honor the President the passing of one bill in committee.
The question is that I do now report to His Honor the President the passing of one bill in committee. Honorable Senators in favor, please say aye. Those against, please say nay. Methinks the ayes have it.
The chairman has reported to me the passing of one bill in committee.
Mr. President, I beg to move that this bill be now read a third time.
The question is that this bill be read a third time. Honorable Senators in favor, please say aye. Those against, please say no. Methinks the ayes have it.
Mr. President, I beg to move that this bill do now pass and be cited as the Whistleblower Protection Act 2021.
The question is that this bill be now passed and be cited as the Whistleblower Protection Act 2021. Honorable Senators in favor, please say aye. Those against, please say no. Methinks the ayes have it. This bill is now so passed and cited.
Order number 3, sir.
Order number 3.
In the name of the Honorable Leader of the Senate, to move the second reading of the Remediation Agreements Deferred Prosecutions Bill 2021.
Mr. President, I beg to move that Your Honor do now leave the chair.
Second reading.
Mr. President, I beg to move that this bill be now read a second time.
The question is that this bill be now read a second time. Honorable Senators in favor, please say aye. Those against, please say no. Methinks the ayes have it.
Mr. President, I beg to move that Your Honor do now leave the chair and the Senate resolve itself into committee for further consideration of this bill.
The question is that they do now leave the chair and the Honorable Senate resolve itself into committee for further consideration of this bill. Honorable Senators in favor, please say aye. Those against, please say nay. We think the ayes have it.
The Senate is now in committee.
Clauses 1 to 12.
Chairman, I beg to move that clauses 1 to 12 stand part.
The question is that clauses 1 to 12 stand part. Honorable Senators in favor, please say aye. Those against, please say nay. Methinks the ayes have it.
Clauses 13 to 24.
Mr. Chairman, I beg to move that clauses 13 to 24 stand part.
The question is that clauses 13 to 24 stand part. Honorable senators in favor, please say aye. Those against, please say nay. Methinks the ayes have it.
Schedule.
Mr. Chairman, I beg that the schedule be the schedule to the bill.
The question is that the schedule be the schedule to the bill. Honorable senators in favor, please say aye. Those against, please say nay. Methinks the ayes have it. The question is that I do now report this honor the President, the passing of one bill in committee. Honorable senators in favor, please say aye. Those against, please say no. Methinks the ayes have it.
The chairman has just reported to me the passing of one bill in committee.
Mr. President, I beg to move that this bill be now read a third time.
The question is that this bill be read a third time. Honorable senators in favor, please say aye. Those against, please say nay. I think the ayes have it.
Mr. President, I beg to move that this bill do now pass and be cited as the Remediation Agreement Deferred Prosecution Act 2021.
The question is that this will be now passed and be cited as the Remediation Agreements Deferred Prosecutions Act 2021. Honorable senators in favor, please say aye. Those against, please say nay. I think the ayes have it. This bill is now so passed and so cited.
Order number 4, sir.
Order number 4.
In the name of the Honorable Leader of the Senate, to move the second reading of the Constitution Amendment number 3, Bill 2021.
Mr. President, I beg to move that this bill be now read a second time.
The question is that this bill be now read a second time. Honorable senators in favor, please say aye. Aye. Those against, please say nay. I think the ayes have it.
Mr. President, I beg to move that your honor do now leave the chair and the Senate resolve itself into committee for further consideration of this bill.
The question is that it do not leave the chair and the Honorable Senate resolve itself into committee for further consideration of this bill. Honorable senators in favor, please say aye. Those against, please say nay. I think the ayes have it.
The Senate is now in committee.
Chairman, I beg to move that clause 1 stand part.
The question is that clause 1 stand part. Honorable senators in favor, please say aye. Those against, please say nay. Methinks the ayes have it.
Clause 2.
Mr. Chairman, I beg to move that clause 2 stand part.
The question is that clause 2 stand part. Honorable senators in favor, please say aye. Those against, please say nay. Methinks the ayes have it.
Mr. Chairman, I beg to move that you do not report to His Honor the President the passing of one bill in committee.
The question is that I do now report this honor the President, the passing of one bill in committee. Honorable senators in favor, please say aye. Those against, please say nay. Methinks the ayes have it.
The chairman has reported to me the passing of one bill in committee.
Mr. President, I beg to move that this bill be now read a third time.
The question is that this bill be read a third time. Honorable senators in favor, please say aye. Those against, please say nay. I think the ayes have it.
Senator Walker.
Senator Walker.
You want to move the passing and citing? You want to move the passing and citing?
Mr. President. I'm doing too many things at one time. Mr. President, I beg to move that this bill do not pass and be cited as the Constitution Amendment Number 3 Act 2021.
Mr. President, as you're aware, this bill is being enacted in accordance with Section 49(2) of the Constitution, therefore requiring 2/3 majority of all members of the Senate present and voting. The Marshal will just check.
Thank you.
Normally we would have had the bell summoning members.
I,
In the absence of the bell.
I missed that bell.
The Marshal has to do a physical check.
It had a certain resonance.
Yeah. Being satisfied, sir, that all members who are present are here, we can now proceed with the count.
Proceed with the vote.
Most Honorable Senator Walker,
Aye.
Senator McConnell,
Aye.
Senator Cummins,
Aye.
Senator Dr. Springer,
Aye.
Senator Dr. Holder,
Aye.
Senator Sands,
Aye.
Senator Grant,
Aye.
Senator Moore,
Aye.
Senator Dr. Hinds,
Aye.
Your Honor, Senator Greenwich,
Aye.
Senator Wiggins,
Aye.
Senator Dr. Rogers,
Aye.
Senator Hunt,
Aye.
Senator Nurse,
Aye.
Senator Boyd.
Aye.
Mr. President, the results of the division, 15 honorable senators voted in favor of the bill. There were no abstentions or noes. Therefore, the 2/3 majority threshold has been satisfied, sir.
Thank you very much, Mr. Clerk, for conducting that process. This bill, having met the constitutional requirements, is therefore no pass and cited as the Constitution Amendment Number 3 Bill, Number 3 Act 2021.
Mr. President, as I rise to move the adjournment, I first of all want to recognize and express tremendous appreciation for the hard work, the Clerk of Parliament, the clerks at the table, the marshals, the technical staff, the secretarial staff of the Parliament, and of course the members of the police services of Barbados. And also, of course, our caterers made it possible, and the persons who work down there, for us to be fed and watered during these long sessions which we've had in the course of December. And I particularly want to commend members of this chamber for their commitment and their diligence coming out in December, week after week, and participating and ensuring that the government's work is done, and by extension, that the work of the people of Barbados is done. We are in the week of Christmas, and I want to wish all honorable members God's precious blessings at this time. I know that there will be a lot of merriment and family get together, and I want to ask all of my colleagues in here, as we indulge, certainly try not to overindulge, Mr. President. I know you'll be cooking, but I don't want members to overindulge with liquid refreshment. And of course, during this season where we get together with our families and there's merriment and excitement, to please remember that we're in the midst of a pandemic, and to beware, to continue to wear your mask, continue your social distancing, and all the practices that have got us safe here thus far. It was a very eventful year. There were some trying periods, as we all know, as we dealt with the pandemic. But within this chamber, the good thing is that we all seem to come together and work when it was necessary in the interest of all Barbadians. I look forward to coming and joining you next year as we continue the people's work on behalf of the government of Barbados. And Mr. President, I want to thank you sincerely for the way you have led this August chamber during the course of this year. And I certainly hope that we will have the opportunity to share a small libation during the holiday season. Mr. President, I'm obliged to you. Let me go. And I move that this sitting be now adjourned. Sign it, aye.
Senator Dr. Rogers.
Thank you, Mr. President. I just rise on behalf of the independent senators to wish everyone a happy and blessed Christmas season. As Dr. Walcott would have pointed out, it has been a difficult year and a half for all of us in Barbados. And at this time, we want to remember especially those families that have been ravaged by the economic fallout and the challenges that they have faced throughout the year and that they will face this Christmas. But by the graciousness of God, I know that there are many organizations out there that are working to seek to put food on the table of every Barbadian this year, and I wish to commend them for the yeoman's service they're given. I also pray that we in our own settings can offer up a prayer for those families that will have voids around their table this year, as they've lost over 250 persons to the dreaded COVID-19 disease. We want to remember those families as they go through this trying period of the year when there's so much merriment, but we know around our tables and in our homes there is an important person missing who will never be there again. And so let us just pray for those families, that those households may experience the peace, love, and care of Christmas as we reach out to those who are going through such trying times. With that, sir, I wish to thank all my colleagues here for making this year the wonderful one that it was. I think we all had a good time here in the Senate, I think. I speak for myself. We all had a lovely time here, and there's still great camaraderie here, and I pray that that continues as we continue to do the business of the people of this country. And with that, once again, I wish you all and all Barbados a happy and blessed Christmas 2021.
Thank you, Senator Dr. Rogers and the Most Honorable Senator Walcott. Let me associate myself with the remarks and to add my thanks to the Leader of Government Business and all government senators, the Leader of Opposition Business and the Opposition senators, and the independent senators. And of course, we cannot do it alone. The clerks at the table play a very important and pivotal role. I think sometimes we see them in the context of the parliamentary experts that they are. But we also must remember that they are the financial, operational, and human resource managers of this Department of State called Parliament, and that the fact that things work, Hansard gets done, the broadcast gets done, whatever needs to be done, the building gets cleaned, is all part of really what they do. And so I want to thank the clerks at the table and the entire staff, many of whom we do not see. They're not visible on the floor, but they're working throughout. Of course, our police officers and the government security guards, the catering staff, and all those who, the technicians, believe they might be from Government Electrical Department or from wherever they're from these days. But I really want to thank the members of the Senate for their active engagement on the matters of major national interest that we've dealt with during the course of the year. Today is our 24th sit-in since the new session began last year, so we have been very much engaged in many matters, and at each sitting we do condense quite a bit of a number of matters from the other place into what we do. It has been an interesting year, tumultuous in some ways, transformative in others. We are now a parliament meeting under very much of a changed constitutional status, the status of a constitutional monarchy. If you remember the reading of the description of Parliament, Parliament used to be read to consist of Her Majesty the Queen, the Senate and the House of Assembly. And that configuration has changed. Of course, we don't have the President and the two chambers constituting of Parliament. And of course, during the year, we are of the people, for the people, by the people, and we cannot forget the trauma that has been visited upon us by COVID-19, the loss of lives, and the loss of livelihoods. We will keep them in our thoughts and prayers. Earlier today, Senator Greenidge, in a contribution, urged Barbadians to get out of their lane, stick in their lane, and to blow their whistle. I would urge, just taking the little poetic license from there, but urge Barbadians to lend a hand. Do not just celebrate for themselves. None of us can be truly happy this Christmas unless we do something to ensure that all are happy. Let us reach out to those families that have lost loved ones, reach out to those families that have lost their jobs, reach out to those families that are in some form of stress or distress. But really, let us, if we all have limited means, so if we need to just reduce the celebratory aspect of our Christmas so that we can lift the spirits of our friends or neighbors or colleagues, a simple telephone call to someone who no longer has that person to fill their lives. But let us make this Christmas one of thankfulness that we're here, but also let us take action. Let us step out of our lane to actually take a positive and proactive step to lend assistance to those who are there. We can no longer say somebody will do it. Somebody being some church out there that we don't go to, some NGO that we don't give support to, some government department that we lobby. Let us, yes, they have to do their part, but let us ask ourselves, what have we done? And unless we can give ourselves a passing mark, don't worry too much about condemning those who are actually out there trying to make things work. And in that regard, I want to salute civil society. There are a vast, there's a vast number, we should say, of individuals, organizations doing much work. Some are well known, others are not well known, but it is really through their private voluntary efforts that much is done. And included in this chamber, there are several senators who are very much involved, or the founders of civil society organizations who are doing tremendous work, not just in faith-based organizations, but in other spheres. So I want to thank those in the wider society, and to assure them that we in the Senate will do our duty, and in fact that we'll go beyond that in ensuring that the time we spend, the effort we make, and the decisions that we reach all contribute towards the further advancement and development of this society in all of its spheres: political, economic, social, cultural, moral. So I wish all of you the very best for this Christmas season, this holy and joyous Christmas season, and certainly all of God's strength, good health, and whatever prosperity we're able to manage for 2022. Finally, I want to thank you for the cooperation which you have given to Deputy President, His Honor Senator Greenidge, and myself. You've made our work interesting but not overly difficult, and I want to thank you for that. I've enjoyed being able to listen to the very interesting contributions made. Sometimes I'm, given my pass, I'm sometimes wishing that I could jump in and say a word or two as well, but to add a little spice to the debate sometimes. But I really do consider it a great privilege and honor to be able to be among you and to preside over the proceedings, the very worthwhile, very useful proceedings of this chamber. So I wish all of you the very best, from my family to yours, and I look forward to continue our important work here for 2022. The question is that this sitting we now adjourn the Honourable Senate. We now adjourn Senate Day. Honourable Senators in favor, please say aye. Aye. Those against, please say no. Methinks the ayes have it. This sitting is now adjourned. The Senate is now adjourned. Senate Day.